Good afternoon. This is Emily Sumner with Sumner Immigration Law. Before we begin, if someone or multiple ones of you could put in the chat that you can hear me, just so that I make sure that my audio is on, that everyone can hear what I'm saying. Awesome. One person, multiple people say that they can hear me. Thanks for confirming. So before we begin, as we go through this, we have a lot to cover today. This will probably last about an hour. But as we go through it, if you have questions that you anticipate that I'm not going to address, or that you feel like you just want to ask, then feel free to put that in the chat. I will try to keep an eye on that, and I will either try to integrate that into what I'm presenting, or hopefully we'll have time at the end for questions. And you can always contact us later if you have a question that we haven't answered in today's webinar. The other thing I want to let everyone know is that this webinar is primarily about the October Visa Bulletin as it relates to employment-based filings. I am not going to be talking about family-based filings. I'm happy to answer questions about the family-based Visa Bulletin, but the majority of the changes or the significant changes that have happened with the Visa Bulletin, the October 2020 Visa Bulletin, are relating to the employment-based tables. So that's what I'm going to be focused on. If you have come here because you have questions about family-based filings, feel free to email us. If you're a current client, if you're not a current client, feel free to set a time for a consultation. We have a link on our website where you can set an appointment. I will say that for family-based filings, we're seeing that interviews are proceeding with USCIS in the United States for adjustment of status filings, assuming the date is current, like for immediate relatives, or if the prior to date is current. And for K-1s and for immediate relatives who are going through the consular processing process, either applying for a K-1 or applying for an immigrant visa overseas, those we are seeing are still stalled. We believe it's because consulates, US consulates, are not fully operating with their full slate of services across the world yet. We are, for any cases that we have active and open, we are, that are, for people who are our clients, we're following up with the consulates to see when they anticipate to reschedule or start scheduling interviews, but we're not seeing movement on that yet. So that's all I'm going to say about family-based. So if you're here for family-based and want to log off now, that's fine. I won't be offended. Not that it matters anyway. So what we are covering today, first, I want to go over just the basic terminology and make sure we're all on the same page and have a clear understanding of what we're talking about. Then a quick overview of what is the Visa Bulletin and how to read the Visa Bulletin. Then a quick overview of what happened yesterday. There was a lot of confusion yesterday, not only for would-be green card applicants and their employers, but also for us as immigration attorneys. So we'll talk about that. We'll talk about how to determine if you can file the application now. And then we'll talk about some what ifs. I am an anxious person and I am trying to get out of this habit, but I like to talk about, well, what if, what if, what if? So if you have questions about, well, what if this happens, or what if that happens, or what if I'm in this situation, we'll talk about some of the common what ifs, the overview of how to prepare the I-45, and next steps, what you need to do now. If there are case-specific questions, or rather fact-specific questions that you have, I probably will not be able to answer that in this webinar, so feel free to email me. And if you're not a current client, we'll set a time for a consultation. If you are a current client, we'll deal with it. We're happy to help you, of course. The other thing is this webinar is for educational purposes only. I'm not giving legal advice through this webinar, and I can't give you legal advice, which is one reason I can't answer fact-specific questions. So terminology. Visa Bulletin. The Visa Bulletin is a document that is published once a month by the U.S. Department of State, which is the agency that oversees the allocation of green cards for the United States. So you might have heard the name Charlie Oppenheim. He's the person who oversees the allocation of available green cards. But Department of State publishes it once a month. Typically, the Visa Bulletin is published, it's published online. So if you just Google, everybody on the seminar probably has already Googled, looked at the October Visa Bulletin, so you know this. But if you Google October 2020 Visa Bulletin or whichever month you want to see, it will come up. Make sure you're looking at the Department of State website and not, an attorney's website or something else. Make sure it's the Department of State website, but it's published online. Usually the Visa Bulletin comes out in the middle of the month for the following month. So typically the October Visa Bulletin would have been published around September 15th for the following month. So of course, everybody, I'm sure all of you and us as immigration professionals, were on the edge of our chairs thinking, oh my goodness, what is going on? Why isn't the Visa Bulletin published? And there were rumors as of last Friday that there would be a number of green cards available for different categories that typically are not available. And we'll talk about that in a minute. Anyway, that's what the Visa Bulletin is. We'll take a look at that in more detail in just a minute. Priority date is the date that you file the labor certification, or the date that it is filed. Or by labor certification, this is the next point. By labor certification, I mean the PERM. It's also referred to as the PERM. It's an acronym that stands for the particular Department of Labor program. But when we say PERM or labor certification, it's the same thing. It's the Form 989, and it's the first step in most, but not all, employment-based green card processes. If you are in a situation where you don't have to file a labor certification first, so for example, Schedule A occupations, which are nurses and PTs, they don't have to go through the labor cert process. We file, it's kind of a hybrid situation, I won't go into it, but we file the I-140 petition. So if you are, let's say, a PT, physical therapist, then the date that your I-140 petition was filed is your priority date. Likewise, if you were to file a national self-sponsor for a national interest waiver or an EB-1A, alien of extraordinary ability, then the date that you filed that I-140 would be your priority date. And that's important. We'll talk about that in a minute. I-140 petition is the second major step in the process, with the PERM labor certification being the first for the vast majority of employment-based applicants. The I-485 application is primarily what we're going to be talking about today and whether or not you're eligible to file that. So the I-485, the form I-485 is the primary form that we use to apply for adjustment of status or apply for a green card. So when we, meaning immigration professionals, say, oh, are you ready to file the I-485? Are you ready to file the adjustment of status? Are you ready to file the application for the green card? All of those mean the same thing most of the time. So keep that in mind, that if you hear terms I-45 adjustment of status, filing for permanent residence, all of that's the same thing. Likewise, immigrant visa, you'll see that term when you're reading about or looking at the Visa Bulletin. The Visa Bulletin technically tells us when an immigrant visa is available. And you might think, well, I don't need a visa, I just need a green card. Then the immigrant visa refers to the issuance of permanent residence status in the United States. So even if you're applying for adjustment of status here in the United States, instead of doing consular processing, you will be allocated an immigrant visa, meaning you'll be allocated a green card, and you'll take a number from the allocation, the overall allocation of green cards. The other thing I want to point out is a lot of times people will ask me about the EAD. They'll say, I'm ready to file for my EAD. EAD meaning employment authorization document, which is also the same thing as a work permit. I want to be very clear that the EAD is a part of the green card filing, but you can't file for the EAD on its own. It's not a standalone filing. It's not like a person could come to me as an immigration lawyer and say, hey, Emily, I want my EAD. It's always part of the green card filing, or sometimes, let's say if you're on H4 status, you're eligible for an EAD, but it's always connected to another particular status. And the EAD is not it's an ancillary benefit that you're getting. It's this kind of a side benefit that you're getting, but it's not the thing that you're applying for. You're applying for the green card, which is permanent residence in the United States. And as I said, if you all have questions as we go through this, then please let me know. So how to read the Visa Bulletin. This is a screenshot of the October 2020 Visa Bulletin, the final action dates table that came out yesterday. The Department of State, or actually not Department of State, but the statute has allocated 140,000 employment-based green cards for everyone who's looking for a green card per year. So that includes the primary applicants and family members, spouses, and minor dependents. So they get used very quickly. As you know, if you are in the process of applying for a green card, you know that it's not a matter of just saying, hey, US government, I want a green card, and they hand it to you. It's not a short-term process, even if you weren't born in China or India, which we'll talk about in a minute. So 140,000 employment-based green cards available every year. The fiscal year starts on October 1st of every year, which is why generally there are fewer green cards available during the summer months, because that's towards the end of the Department of State and USCIS fiscal year, and more generally available in October, November, which is the beginning of the fiscal year. So that's why in October of this year, and it's happened other years too, we see that there are more green cards available because they're starting over. Furthermore, the Department of State, and it's very complicated, I'm not going to get into the exact calculations here, but they will take unused green cards from family-based categories, and also they will trickle down unused green cards from these categories, the employment, I'm pointing as if you can see me pointing, from the top categories, EB2, EB3, they will trickle down, unused green cards will trickle down, immigrant visas will trickle down to subsequent categories. So that's why we have, one of the reasons that we have this seemingly huge influx of green cards that are suddenly available right now. Another thing that you need to be aware of is that no country, so we have these countries listed across the top, China, India, Mexico, Philippines. Now, as of a couple of years ago, they have another category for Central America, El Salvador, Guatemala, and Honduras. So they have these categories of countries across the top, and also Vietnam. These categories are there because no country can, this is by statute, again, no country can take more than 7% of the overall allocation of visas. So no country can take more than 7% of that 140,000 employment-based green cards available per year. We generally have so many immigrants from these particular countries, China, India, Mexico, Philippines, Vietnam, and these Central American countries, that they have their own separate categories. That doesn't mean they get it does mean they get fewer green cards in the sense that they're capped at 7% of the overall allocation. And then every other country falls into this category that you see on the left here, all chargeability areas except those listed. So in figuring out and thinking about when or whether you can file the I-485, you have to think about the country that you were born in, not the country in which you were in which you've become a citizen. So if you were born in India and now you're a citizen of Canada, that's fantastic, congratulations, but you're still a citizen of India. You're still, rather your country of birth, your chargeability is still India, regardless of what your current citizenship is. So make sure that you're paying attention to country of birth. That being said, there is something called cross-chargeability, which means that you can take advantage of the country of birth of your spouse, even if you are the primary applicant. So I've had this happen a handful of times over the years. In one instance, the primary applicant was born in India, his spouse was born in Germany, and so we filed an employment-based green card for him based on the wife's country, Germany, and they were able to file much faster. So that's something to keep in mind. If you are married, make sure that you check to see which country of birth your spouse is in. I'm just going to make sure that everybody's muted because I thought I heard something. Okay, I guess not. So check country of birth. The other thing is the categories listed on the side here. EB1, EB2, EB3, you might have heard us talking about this. EB1 is generally for it's for foreign nationals who qualify as aliens of extraordinary ability, so the EB1A. It includes EB1B, which is outstanding researchers and professors, and EB1C, which is multinational executives and managers. That's analogous to the temporary visa classification of L1. So it's not enough to just be a manager or executive. You have to meet very specific requirements. EB2 is for national interest waivers, which are self-sponsored, or positions that require a master's degree or equivalent. which is defined as a bachelor's degree, single source bachelor's degree, followed by 5 years of experience. EB3 is for positions that require a bachelor's degree or 2 years of experience. And then other workers, this is like the skilled workers category, is for positions that require less than that. So less than a bachelor's degree and or less than 2 years of experience. These other categories, the religious workers, I'm not going to talk about because we don't have we don't have many clients who fall into that category. EB5 we don't handle, so I'm not going to talk about those. We're going to focus primarily on EB2 and EB3 because that's where the vast majority of our clients fall. So again, this is the visa bulletin for the October that was published yesterday, and it's the final action dates. So if you look at this, the final action dates table, C is in a lot of these categories. So C is for all the way down for all chargeabilities, for Central America, Mexico, Philippines, and Vietnam. That means that if you were born in one of these countries and you fall into one of these categories, then you could, depending on which chart USCIS is using, and we'll get into that in a minute, then you could file for the green card. However, if you look at these dates, these are priority dates. So that means that if your priority date, let's say that you fall into the EB2 category for China, you were born in China, and you fall into the EB2 category, the priority date is March 1st, 2016. That means that if your priority date is before that date, meaning if you filed the labor certification before that date, you're eligible to file for a green card. Again, caveat to that because we have to see which chart USCIS is using. So this is the final action date chart. The next slide here is the dates for filing chart. So this also was on the visa bulletin. It is on the October visa bulletin. It was on it yesterday. It was published yesterday. And if you look at the dates, the C's are consistent for the most part for Mexico, Philippines, China, Central America, all chargeability areas. However, if you look at these dates under China and India, they are different from the dates you may have noticed that are under our final action dates. So why is that? Well, this may be more information than you want to know, so bear with me if you're not interested. But you may recall, depending on how long you've been on this journey, you may recall that in September 2015, the dates became current or moved up significantly for a lot of the employment-based categories. And we started preparing applications and immigration attorneys across the country, of course, because the dates were current. And then USCIS said, we have enough filings, that's okay, you can stop now. And at the time I thought, okay, somebody's gonna sue Department of State and USCIS and it'll be fine, we can keep filing. That was not successful. Somebody did sue, but it was not successful. As a result of that, and I say that because in 2007, July 2007, something similar happened and USCIS said, okay, fine, we'll accept them. But that did not happen in 2015. So because of that, now after that happened, the USCIS, the Department of State and USCIS coordinated and they said, okay, we'll have 2 separate charts. One that's final action date, meaning yes, a green card is absolutely available for this particular category. And then we'll have another table for dates for filing, meaning we, Department of State and USCIS, think that these priority dates will become current soon. So we want to allow these people to go ahead and file. That's why we have the 2 separate charts. However, USCIS, when that happened, USCIS said, oh, no, wait a minute. You Department of State don't get to tell us when we accept filings. You don't know how many we have, you can't do that. So now we have these 2 separate charts, both under employment-based dates, or under the employment-based category, not family-based, but employment-based. But now we have to wait after the visa bulletin is published to see when USCIS or what USCIS tells us as far as which date they're going to use. And I didn't screenshot it, but yesterday the Department of USCIS, there's a special web page. If you Google USCIS dates for filing, it will come up. Make sure you're looking at the USCIS website. But yesterday, so when the visa bulletin was published yesterday, we'll go over this now. The visa bulletin was published around 8 a.m. yesterday. As I said, it was very, very much anticipated. We were wondering where on earth it was. And it looked really exciting, right? You look at the visa bulletin, and of course, we start getting phone calls and emails and text messages from clients saying, I can file my I-45. Everybody's so excited. And we spent the morning, we, meaning some immigration law professionals and our colleagues across the country, spent the morning saying, okay, well, that's great, but you have to wait and see what USCIS says, which table they're going to use, and trying to explain that. So that's what we spent yesterday morning doing. Early yesterday afternoon, USCIS updated their webpage where they tell us which table they're going to use. And they said, we're going to use final action dates only. And I thought, okay, that's expected. It's not good for our clients because most of them can't file because their final action date isn't current, just the dates for filing. So I spent most of the afternoon explaining that to people, telling them, unfortunately, we can't file, we'll be in touch, all of that. Then 4 o'clock yesterday afternoon, USCIS changes, they refreshed their webpage and they changed their mind and they basically say, just kidding, we're actually using dates for filing. So then I, again, was emailing everyone saying, okay, there's another change and we're using dates for USCIS is using dates for filing now. So that's what happened yesterday. That's why there was so much confusion yesterday amongst everyone, basically, would be applicants and employers and attorneys about which particular chart was being used and whether you would be eligible to file. So the question now is, are you eligible to file for the I-45? And again, the I-45 is the dates, the I-45 is the application for the green card. So this is really something that you need an attorney to help you determine. I would not recommend you file a green card application on your own anyway. But these are the things, just so that you know, that we look at, the analysis that we look at. We look at your country of birth or cross chargeability. Again, if your spouse was born in a different country, that's something that we need to look at. But look at your country of birth. Look at your priority date. Is your priority date current for EB2 or for EB3 or EB1 or EB5 if you fall into those categories? But look at your priority date for EB2 or EB3. The reason I say that is because it goes to this next point. Do you need to file an I-140 petition downgrade? If you look at the dates for filing, which again is the visa bulletin that USCIS says that we can use, if you look at the dates for filing, especially for India, also for China, but there's a bigger difference for India. If you look at the dates for filing for EB3, which is really a lower category in the sense that it doesn't require as much education or possibly experience, these dates are more advanced, they're better dates than EB2, which is typically not the case. We think that this has happened because of the trickle-down effect that I was explaining earlier, and because for years and years and years, so when I first started practicing in 2005, we saw a lot of upgrades. In other words, from EB3 to EB2, because the dates for EB2 traditionally were better. It was faster. So a lot of people either wanted, when they were starting the process, they wanted to fall into the EB2 category if they accurately could, or if they were in EB3, they tried to upgrade, and some did successfully, to EB2. So now that it's like so many more people qualify now for EB2 than EB3, that EB3, there's more space in the EB3 category. So that's why that's happened. But look at the dates for EB3 for India. It's January 15th, 2000. Sorry, I'm reading this wrong. It's January 1st, 2015, not 2001. January 15th, January 1st, 2015 versus May of 2011. So there's a huge gap here, a 4-year difference. So you might be thinking, okay, what if my petition, my I-140 petition was approved as an EB3 petition? Then what can I do? You can actually downgrade to an EB3 petition. And we'll talk about the logistics of that in just a minute, but just know that it is possible if you have an I-140 petition approved in the EB2 category to downgrade to EB3. And then another thing to consider is the employer who sponsored you willing to continue sponsoring you? That's critical. So the perm leaver certification, this whole employment-based green card process is for prospective employment, meaning you as a foreign national employee do not have to be employed by the employer who's sponsoring you at any certain time until you get to the point of receiving the green card. Once you receive the green card, you absolutely need to work for that employer. And leading up to that time, you do have to have the intention to work for the employer, and the employer has to have the good faith intention to hire you, at least as of the time that you receive the green card. And you can work for the employer during that time or not. There might be a situation where, for whatever reason, you go work for someone else and then you return to the employer who sponsored you. But it's critical to check to make sure that that employer who sponsored you is willing to proceed and to continue sponsoring you, because A, you're attesting to the government by filing the I-45 that yes, you intend to have that position at least when you get the green card. So you have to make that attestation in good faith, obviously. And you have to file the form I-45J, which is a form where you confirm that you and the employer confirm that you both intend for you to have that position, at least as of the time that you have the green card, and confirming that the position still exists. So if you are in a situation where we'll talk about this in a minute. I think we're coming up on the what ifs. But if you're in a situation where you have an employer employer A, let's say, sponsored you for permanent residence, and you have the I-140 approved through them, and then you moved to employer B, and you either haven't started the green card process with them, or you've started it, but you don't have an approved I-140 petition, then in that case, you need to either talk to employer A or not be able to file right now, which is fine. You might not be able to file right now, and that does not mean you'll never get the green card. It doesn't mean that you should give up hope or stop the process or anything. It just means that you're not eligible to file at this particular moment. But that's something that you need to keep in mind and think about. So what if? Like I said, I have a touch of anxiety here and there, and sometimes I get in this mind frame of what if, what if, what if. In this particular situation, it might not be so much anxiety, but more just wanting to know, this is my situation, Emily, what do I do about it? So we've tried to address some of the common situations that we've had clients ask us about. The first one is, what if I have an approved EB2 I-140 petition, but my priority date is current for EB3? As I said before, it is possible to downgrade, and we'll walk through some of those logistics in just a minute. What if I have an I-140 petition approved with employer A, but I now work for employer B? That's what I just mentioned, that you have to have a perm labor certification and really I-140 filed and approved in order to continue with the I-485. You cannot, I had a situation yesterday where a client said, well, I have a perm approved and an I-140 approved for 3 employers ago, but I haven't filed anything since then, and I haven't filed with my new employer, and I'm not able to return to that employer who filed for me. What can I do? And unfortunately, in that situation, like I said, you're not able to file the I-45. Again, that doesn't mean you'll never file the I-45. It doesn't mean you'll never get the green card. It might feel that way right now, but that's not the case. So if you're in that situation where a previous employer filed for you, you're not able to go back to that employer or have the good faith intention to go back when you get the green card, then work on getting things underway now with the perm and the I-140 for your current employer, so that when this happens again, you'll be set to go. What if you already filed the I-45? You probably don't need to do anything if you already filed the I-45. If you see that the final action dates are current for your particular category and you're still with the same employer, then it's a good idea to follow up with USCIS either through a service request and/or letter to USCIS to remind them that the priority date is current. Sometimes they don't catch a case, so it's just a good idea to remind them. There is the possibility of AC-21 portability. I'm not going to get into that right now because it's a little bit more complex than we have time for, but let me know if you're in a situation. Just know that if you are in a situation where you file the I-485 and you then need to move to a different employer, it may be possible to do that. What if you can't file in October? So the October visa bulletin has come out. It's valid for the month of October. We anticipate that USCIS will accept filings for the full month of October right now. However, we don't know what's going to happen in November. The November visa bulletin, I hope, will come out by mid-October. I hope there won't be as much drama with the unveiling of the visa bulletin as there was for October. So we should have some heads up, but it's possible that the dates would retrogress in November. It's possible they would advance some more, but it's possible that they would retrogress. The other unknown is, even, let's say the dates progress, they move forward for November, which would be great. We still don't know for sure whether USCIS is going to, which table they're going to use, if they'll still accept the dates for filing, or if they'll go back and say, no, just the final action dates. So if you're eligible to file now, you need to be prepared to file in October and get it done this month. It's possible that if you're not able to get it done this month, then you would have to wait some time before you're able to file. So downgrading an I-140 petition, I can't tell you how many emails I've received about this. So I'm happy to try to explain this. Yes, it is likely possible. You have to have the same employer who filed your perm labor certification. As I said before, you don't necessarily have to be working for that employer right now, but you do have to intend, and your employer, that employer, the prospective employer, has to intend to hire you at the time that you receive the green card. If you're in a situation where, I think I mentioned this before, but if you're in a situation where you've moved employers and you have not started the green card process with them and you don't intend to go back to the originally sponsoring employer, you're not able to file the I-485 right now. A lot of you, I think, know this, but you can retain the priority date from a previous filing. And we've done that for, I know, for a number of people that are on this webinar right now. But if you, let's say you file the permanent I-140 for employer A and your priority date is May 15th, 2010, just as an example, then you can retain that priority date when you move to employer B and you file the perm and labor certification with employer B. You can retain that priority date for the new I-140 filing. So you have to start everything over again. You have to file the labor certification and then file the I-140 petition, because it is employer specific. You can't just say, oh, I have this perm labor certification and I'm in pretty much the same position and my job duties are pretty similar, so I'm just going to transfer it over to this new employer. No, you have to start the process all over again. But once you go through that process of getting the labor certification approved, when it's time to file the I-140 petition, you can port your priority date. Somebody has asked what happens to the EB2 status if we downgrade. That's an excellent question, and I think I have it covered in the slides, but let me know, remind me again if I don't cover it in just a minute. Can we file concurrently? You can file concurrently. Oh, let me go back, I missed this one. You file a new I-140 petition. So let's say that you are with the same employer who filed the EB2 petition that you need to downgrade. You have to file a new I-140 petition and request the EB3 category. It's not a matter of just sending a letter to USCIS and saying, hey, I want to use the EB3 category. You file a completely new petition. You still have to prove ability to pay. All the things that you have to do for a regular I-140 petition, you have to do for a downgrade petition as well. You reuse the labor certification. So if you are filing a downgrade, you need to make sure that you have a copy of that labor certification. If we filed your original labor certification, we meaning Sumner Immigration, we of course have that on file and we're happy to pull that. There's some situations where we've had corporate clients come to us in the past few years and they maybe filed perms with a previous attorney and we don't have access to that. So if that's a situation that you're in, you want to make sure that you are able to access the labor certification, the perm, because we do need that to begin that process, the I-140 downgrade process. You can file concurrently. So you could file the EB3 downgrade and the I-485 at the same time. And that's what I would recommend, because we don't know how long this window of filing is going to last. Yes, this said I'm answering the question right here. You can interfile later. You can keep both options. So One person asked, what happens to the EB2 if we downgrade to EB3? You're not getting rid of it. You can have two I-140 petitions that are both valid and active. So in other words, if you downgrade to EB3, that does not negate or cancel your EB2 petition. So what happens down the road when the priority date becomes current, because you're not going to get your green card right away. I think I'm going to mention this in the future, but you're not going to get your green card right away if you file right now, especially if you were born in one of these countries that still has retrogressions like China or India, and you're filing based on the dates for filing categories, you're still probably going to have to wait years for a green card. It's not going to be immediate. So what if down the road, let's say in 18 months, the EB2 date is actually better, quote unquote, or let's say it's active, it's current. For final action dates, then you would have to interfile, is the legal term, the name of the process that is used. You'd have to interfile the approved I-140 petition with the pending I-45. So you would not have to file the I-45 again, but you would have to let USCIS know, hey, I have this approved I-140, EB2 I-140 petition. It's not what I filed, it's not the basis on which I filed the I-45. I want you to attach it. And it is a challenge because there's no form for it. So it's hard to get USCIS to pay attention because in the mailroom, they're like, we have this letter. I don't really know where it goes or what to do with it. So it's hard to get it matched to the file and then get the officer to take action. I've done it before successfully several times, so it is possible. I would not let that, I don't make decisions for clients, so I don't want to tell you what to do. But I would not let that process deter you from filing an EB3 downgrade right now so that you can file the I-45 now. We have another question. Do we need to do the I-140 downgrade in premium processing, or does the downgrade timing affect the I-45 application? You could try, so there are two, to answer your question, no, you don't have to do the I-140 downgrade in premium processing. It would not affect the I-45 processing for two reasons. One is, yes, the I-140 has to be approved before your green card is approved, but especially if you're filing in one of these, if you're filing as a Chinese or Indian national, somebody born in one of those countries, you're not getting a green card anytime soon, unfortunately. It's great that you can file now, but you're not getting a green card anytime soon. So there's not an advantage that I see to filing in premium processing. The other thing is it's a question of whether you can file in premium processing. In general, USCIS says that if we're not filing with the original labor certification, which we would not be. When I say original labor certification, I mean the blue paper that Department of Labor sends us when there's not a pandemic. So there's not an original labor certification. So there's already been discussions amongst immigration attorneys as to whether it's possible to file in premium processing. The general consensus is nobody knows. You could try, and worst case, they would send back the premium processing fee if they can't accommodate it. So how do I file? I know we've had more questions come in. I'm going to keep going, but keep asking questions and we'll come back to these. How do I file the I-45? What are the logistics? The general requirements are, A, you confirm with your employer that your employer is willing to continue sponsoring you. As I said, you cannot do this on your own. You cannot just say, oh, I have a perm that was approved 5 years ago with, two employers ago that I had, and so I want to go ahead and file because I have an approved I-140. No, you have to confirm that they're willing to continue sponsoring you because you're attesting to that, and you are also needing to file the I-45J and get the employer's signature on that. Gather the documents that are required. We provide our clients with detailed document checklists. We generally don't provide that. We don't provide that, the detailed document checklist until you have retained us, because we see that as a central part of the legal services that we're providing. So we want to make sure that we preserve that value for clients. I will say that I'm going to give you some tips at the end before we conclude. But as far as the medical exam goes, again, you can do whatever you want, but just know that it is not required to file with the medical exam. If you choose to just go ahead and file now without the medical exam, then USCIS will RFE for it later. They'll send you a request for evidence asking for it later, but it's not required to file with it. If you do file with the medical exam, it has to have been completed within 60 days of filing. So if you had a premonition that this was going to happen and got your medical exam in July, then it's going to be too late, and it won't be valid. The other thing is medical exams are valid for 2 years, so likely your application will be pending for more than 2 years, so you would have to get another one anyway. Again, up to you, but that's the information to help you make that decision. The forms that are required, I'm not going to go through every single form that's required, but know that the form I-944 relates to public charge, which is a new regulation that the Trump administration published / tried to publish. It's part of ongoing federal litigation. It's been on again, off again for months and months and months, lots of confusion. The current rule, we just got guidance on this as of Monday, I believe, or last Friday, and that is that it is required now nationwide. If you file an I-45 that's received before 1013, they will only send a request for evidence if you file without it. If you file so that your petition is received or application is received on or after 1013, then they will require it, or else if you don't include it, it will be rejected, and you don't want that. So I would plan, because you don't know exactly when you're going to file, I would plan to go ahead and submit the I-944 and all the required documentation. You can apply for a work permit and travel document, EAD and AP, at the same time. Keep in mind that the processing times for those are inconsistent, I will say. Before the pandemic, we were saying that it was taking about 6 to 9 months. Then the pandemic hit and everything was kind of on hold because USCIS wasn't able to do biometrics, which they require before they approve these. And now we've had a couple that have been approved within a couple of months. So I wouldn't count on that as an immediate solution for being able to work. You can include your family members at this time, but they have to be physically present in the United States before or when you file the application. So if you have family members overseas, they need to come home right now if you're thinking of filing in October. Fees. The USCIS filing fees as of October 2nd are $1,130 per person, which is also for minor children. They used to, USCIS before this fee change had a lower fee for minor children. That's no longer the case. Furthermore, there's a separate filing fee for the EAD, the work permit, and the travel document, the AP. And those are listed there on the screen, $550 and $590. So it's around $2,000 total per person that you would have to pay depending on what you want to request. It's possible to file the I-45 and not request the EAD or AP. And then for legal fees, contact our office. We'll have information on next steps to get that information and to get everything started. Just checking the time. So the services that we provide, a lot of people say, well, this is just forms. Can I do it myself? Sure, you can give that a whirl if you want to. But the services that we provide are, we provide a thorough review and assessment of all of the documents that are required. We, of course, advise you of all the documents that are required, give you a detailed document checklist. We use our experience and expertise to advise on the issues that come up. We are available to answer your questions. We try to integrate frequently asked questions into our template emails so the clients know proactively, like how to get their driver's license if you don't have that yet, or what about the social security number, what about travel, things like that. We will keep you abreast of any changes in immigration law or policy that can affect your case, and then we have a separate preparation session before the interview. As part of the service of preparing the I-45, we also prepare the forms. Some people think that they should prepare the forms and then give them to us. No, we will prepare the forms. There are certain ways that they have to be completed, as you can imagine. So that's something that we do for you. We would send you an online questionnaire to gather the information, and then based on that, we prepare the forms. So if you're saying, okay, this sounds great, I think I'm eligible, I think I'm ready, what's the next step? And you guys keep sending me your questions, and we'll take a look at them in just a minute. So step number 1 is complete the client intake. You'll need to go to sumnerimmigration.com/next-step. It is case sensitive. Here we have it uppercase, but it needs to be lowercase, is my understanding. So type it in lowercase. If you can't access it, email us. We're happy to help you. But you complete the client intake form there. There are two options. You can either just say, yes, I'm interested in basic information, but I'm not ready to commit to proceed right now. Or you can say, here's my name and contact information. Yes, I'm ready to go. And then we'll ask you for a little bit more detailed information. It's not the online questionnaires, but it's things like, what's your priority date, your country of birth? Do you need to file an EB3 downgrade, that type of thing. And Cindy just put in the comments the exact link with the lowercase, so you can just copy and paste it from there. And it's also on the next slide, and we're also going to email it to everybody. So next step is signed engagement letter. The engagement letter is a contract, our contract, that says what the fees are going to be, what it includes, what it doesn't include. And then you would need to make the first half of the legal fee payment. I don't think I covered this. It might be in the next slide, I can't remember. But anyone can pay for these processes, the I-140 and the I-45. Either the employer can pay or the employee can pay, or in theory, someone else can pay. So if grandma wants to pay for your green card, go for it. But anyone can pay, but you have to make the first half of the legal fee payment to begin the case. We would send the initiation email, which is the detailed document checklist and the online questionnaires. You would complete the questionnaires and upload the documents. And then we would prepare all of the forms for you, start assembling the case. We would email you the forms for review, for you to print, review, and sign, and then return to us. If you decide to proceed with this, make sure that you take note of the mailing address. We're still all working remotely because of COVID. So there's a very specific mailing address that you should send it to that is not the office address. If you send it to the office, it's not the end of the world, but we prefer you to send it to the address we specify. Then we, SIL, Summer Immigration Law, would assemble and review and do the final QA check. That's a big part of our process, is the quality assurance check. Obviously, we want to make sure everything's correct, but also we want to make sure that we have everything assembled correctly, all the documents and the forms are completed correctly, the checks are correct, it's then going to the right place, because that can cause a rejection. So that's a huge part of what we do. We have multiple levels of that and multiple sets of eyes and brains looking at that. And then we email the client and let them know that we have filed, and then you wait. We think that there's going to be a big surge of filings, as you can imagine, with USCIS. So I think that it's possible that there'll be delays in receipt notices and biometrics. And then, as I said, you have to wait until the priority date is current before you're eligible for a green card. Right now, the USCIS their policy requires an interview for most employment-based cases. During COVID, they actually waived that. We had several clients who were able to get the green card without the interview, but there's an employment-based interview that could change, especially if and when there's a new administration. But there's an interview down the road, and we'll help you prepare for that if that comes up. So other frequently asked questions. Who can pay for this process? I just covered that. The employer can pay, the employee can pay. You can split it half and half or however you want to, but it's not like the perm labor certification where the employer has to pay for the process. So if you as an employee are willing to pay for it and your employer is good with that, that's fine. Or if the employer wants to provide it as, pay for it as part of an employee benefit, that's fine. Just let us know who's paying. How long will it take? So we, as far as the preparation goes, it usually takes at least a couple of weeks from the time we initiate the process to the time that we're able to file. For the month of October, obviously this will be our focus, making sure that we get everything in as quickly as possible. I totally understand that you want your petition, your application filed as soon as possible. We are doing everything on a first in, first out basis, meaning the first in is defined as when we receive the first half, the signed engagement letter and first half of the payment and the completed questionnaires. And then you'll kind of be put in the queue for preparation and filing. So the sooner you can do that, the better. What would prevent me from filing in October? First of all, like I said, you have to make sure your employer is willing to continue to support you. If your priority date is not current, that would, not current meaning per the dates for filing, this unfortunately is not available for everyone. If you have priority dates that are later than the date and that dates for filing Visa Bulletin, then your turn is coming, but it's not today, or not this month, not October. So make sure that your date is actually current, that you can actually file. If you have certain criminal issues, it may be that you don't want to or can't file. We would advise you on that. I think those are the main reasons that you wouldn't be able to file. And we'll of course advise you of that. If we take a look at your documents and your situation and we say, you know what, this isn't going to work, we'll let you know that upfront as soon as possible. The next step to take, if you're interested, as I said, is going to this website. Cindy also put it in the comments, and we'll also email it to you. But go to this website. It's a Google form. And like I said, there are two options. You can either indicate that you just want more basic information, and it's pretty straightforward, basic, quick information. Or you can indicate that, yes, I'm absolutely ready to go. And if that's the case, we'll ask you for a little bit more detailed information so we can know exactly what we need to do to help you in terms of whether we're filing a downgrade as well or just the I-45. So if you want to take action immediately, I have some weekend homework for you. Here's what you need to do. You need to locate your passport, make a copy of your passport, your visa, your I-94 card, your most recent H-1B approval notice or other, if you're on H-4 or J or F-1, whatever your situation is, that most recent immigration approval notice. Find your birth certificate. You need a birth certificate to file. This is not optional. It is considered initial evidence. I do not want to file applications without your birth certificate because it could be rejected. We have a video, it's about 2 or 3 minute video on YouTube. If you Google Sumner Immigration YouTube birth certificate, it should come up, and we'll send that to you in the email that we send after the webinar as well. But that explains, we also have a blog post on this. You might be able to tell this is something that's come up a few times in the past. So you have to have your birth certificate. If you don't have a birth certificate, let us know. We'll advise you on that. There's something called a reciprocity table published by Department of State that tells us whether or not that's okay that you don't have a birth certificate. But we'll help advise you on that. That's part of what we do. One person says, what happens if we don't have an English birth certificate? You need a translation. So sometimes the birth certificate is in English itself. Sometimes it's in your language and there's an English translation underneath it, which is fine. And then sometimes it's not in English at all, which is also fine. You just need a translation. It can be translated by anyone who's fluent in both languages, and you just include a certificate of translation at the end. And we'll help you with that. So find your birth certificate, likewise your marriage certificate, birth certificate for children, your educational docs. So these last three documents go to the I-944. And Cindy just put or someone, looks like not Cindy, somebody put a link to our video on the birth certificate. Thank you, whoever put that there. So educational documents, it might have been Nikita who put that. She did the video, it's awesome. She's our I-45. She does them a lot, she's great. So educational documents, you need those copies of the degrees and transcripts. Again, this is for the I-944 form. Request your tax transcript through the IRS. If you go to the IRS website, you can request it online. It can take a few days to get. Obtain your credit report and score, again, required for the I-944. If you're an employment-based client, then you should have a social security number and be able to get it. If for some reason you don't have a social security number, like let's say there's an H-4 spouse who doesn't have a social security number, you're not going to be able to get a credit score. And in that case, we just have you try to get it, like go to the website and try to get it. And then we include a printout that says, you need a social security number. Yes, it's ridiculous, but that's what we do. So that is the conclusion of the information that I have. We have a few minutes left, and I want to try to address some of the questions. Before we go there, ways to stay updated. Hopefully there are not major changes to this, but you know there'll be changes to immigration law in general. So ways to keep updated on that are read our blog posts. We post on our website regularly. It's sumnerimmigration.com. Join our newsletter. We send a monthly email newsletter. The one that we sent yesterday is the one that's basically our October newsletter. We most of the time send newsletters just once a month. RSVP to future webinars. Also connect with us on social media. We're on Facebook. We need to update this. We're now also on Instagram and LinkedIn. With LinkedIn, connect with our Sumner Immigration page, but also connect with me, with Emily Sumner, because I've started posting really detailed updates there on a regular basis. So that's a great way to catch cutting edge information and tips. So let's take a look at our questions now. Oh, I got rid of the questions. Okay. I'm going to try to do this on a first in, first out basis. And like I said, if they're really detailed, then I'm not going to be able to answer them. Moved from company A to company B. EB3 is with company A as current. EB2 with company B is not current, but has the same priority date. Am I eligible to file for I-45? That's a pretty fact-specific question, but it sounds like, contact me, but it sounds like you should be able to file an EB3 downgrade based on the EB2 category that you have. So this is a great question because it shows how you can use the best of kind of everything that you have. This person, it sounds like, is using, he has an EB2 or she has an EB2 petition and an EB3 petition, but let's say with company B, the company they're working with right now, they have an EB2 petition and the priority date from the previous filing. That's, I mentioned earlier that you can port the priority date. So this person would port the priority date or has ported the priority date from the earlier filing. They can use that, and then it sounds like we can downgrade to EB3. Contact me, but I think that that's what we can do there. We talked about what happens to EB2 if we downgrade to EB3. We talked about premium processing. My I-140 was approved in 2013 through employer A. Last year, I joined with employer B. Previous employer canceled my I-140 after I left. Again, I joined back with employer A recently. Do I need to start the green card process again, starting from labor, or can I file my I-140 directly without filing labor? Kindly advise. That's a good question. So it sounds like you were with employer A, went to employer B, now came back to employer A, but they've withdrawn, it sounds like they've withdrawn the I-140 petition, in which case you get legal advice on this, contact me or a qualified immigration attorney. I'm happy to help. But it sounds like you should be able to just refile. Sounds like they have officially withdrawn the I-140 petition, meaning it's gone. And that you should refile the I-140 petition, and you should be able to use the labor certification, but get legal advice on that because I don't want to tell you the wrong thing, not knowing all the dates. EB3 with priority date of November 2015. With my current employer, should I file for the EB3 or EB2? I'm not sure if this person is asking whether they should file the I-140 or perm, so reach out to me and I'm happy to advise you on that. But in general, you have to file according to the priority date that's current. So if you look at the dates for filing category table and your priority date is current for EB3 but not for EB2, you would have to have an EB3 filing, either previously or file a downgrade. But you can't just say, oh, my priority date is current for the EB3 category, but I have an EB2, I'm just gonna file the I-45 and tell them about that. No, you have to have an approved I-1, or not necessarily approved, but you have to have an EB2, I-140 based on the EB3 filing category. Filed with previous employer, do we need to move back to the previous employer after EAD received or the green card? Okay, technically you have to move back to, if the previous employer is willing to continue sponsoring you, then you have to move back at least as of the time that you receive the green card, not necessarily when you get the EAD, but it has to be done in good faith, of course. Eligible for downgrade to EB3, but my spouse's H4 is under process right now. My H1 is approved. Can we still file for I-45 jointly? Yes. So it sounds like the concern is that the H4 extension is still pending. That's fine. As long as we've timely filed the extension, yes, you can still file the I-45. What date does USCIS consider as a filing date if we submit I-140 and 485 at once? USCIS takes 3 months for the processing of I-140. After 3 months, they may not honor filing date anymore, or the dates can retrogress. I'm not sure that I understand this question. Would they still consider the date we sent our application when they start processing the 485? Yeah, so if you file the I-140 and the I-485 concurrently, and you file in the month of October, and your priority date is current for the I-140 that's either approved or that you're filing in October, then you're fine, even if the dates retrogress later. So if the dates retrogress later, and I really think they will, then USCIS will continue to process the I-140 petition, and hopefully that'll be approved. And then they will hold the I-45 in abeyance. That's a legal term, just meaning they'll shelve it until the priority date is current again. Priority date is March 2010. Can I file the I-45 now? Look at the visa bulletin, but probably so. Depends on your country of birth and category. Does the filing of I-45 go in parallel with getting the actual green card, or is green card only processed when the final action dates are available? The latter. That's a great question. So and that's what I was saying before, you're still going to have to wait. Even if you can file the I-45 now, then you still are going to have to wait until the priority date is current. The final action date is current before you receive the green card. So it could be years and years and years that this is pending. We've had clients that has happened to them before. I'm going to address 4 more questions and then we'll log off so that you all can get back to work, and we can too. Eligible for downgrading to EB3, spouses extension. I think I already answered this. Yes. What will happen after we apply downgrade in I-45? Then everything will be pending. Hopefully the I-140 petition will be approved. The I-45 will be pending at least until the time that your final action date is current, and then the green card could be approved. 2 more. What date does USCIS consider as a filing date if we submit I-140 and 45 at once? Yeah, I think I tried to answer that question before, and I may not be understanding your question correctly. So feel free to email us if you still have that question. But they would consider the date that you sent the application as the date that they start processing the I-45. Can we withdraw both the new applications if we want to at a later time when they are in process? Yes, if you wanted to withdraw the I-140 and or 45 later, you could. I'm not sure why you would want to, but you could do that. All right, 1 more. I'm with same employer, I-140 approved in EB3, February 2012, kind of downgrade to EB3. So I can't answer specifically for each individual person here because it's that specific. I'm gonna have to do the analysis, but in general, if you meet the requirements for EB2, then you meet the requirements for EB3. So in general, yes, it's possible. I'm not sure what I'm not supposed to say. Oh, I think you do. You don't like me saying that it's gonna be pending for a long time. Sorry, it is. All right, we have lots more questions. I will go through them, and if I have your email address, I will try to answer them. Otherwise, feel free to, let me look at this last one. USCIS went out to their website, which table they'll use for the month of October. So there's one last question that I think is important. USCIS will announce on their website which table they'll use for the month of October. Therefore, right now, we have to wait for that announcement to determine whether you can file in October, or we'll have to wait, will it be published in October? No, that information is already published. USCIS published it yesterday, and that's what I was saying at the beginning of the webinar. They originally said that they would use only the final action dates, and then around 4 o'clock yesterday, they said, nope, we'll use the dates for filing. So we already have that information, and we know that we can use the dates for filing. All right, I'm so glad that you all joined us. Thank you so much for coming. I hope that you found this helpful. And yes, we will send a copy of the recording to everyone who registered. I hope that you found this helpful. I hope you'll share this information with your friends. Fill out our form, whether you're interested in just basic information or if you know you want to proceed, and we look forward to helping you. You guys have a great afternoon.